So yesterday, two rogue judges declared that Texas cannot redistrict in the middle of a decade. They claim that what Texas is doing is unconstitutional, despite the fact that the state constitution literally allows Texas to do this, and that what they're doing is supposedly racist, even though what they're trying to do is undo the racial gerrymandering, which is harming all the citizens of the state. According to these two rogue judges, Texas has to stick to the map that was decided in 2021. Well, we should have known that there was something off about this decision. Usually, when the majority's decision is made public, you also get the dissent, but notably missing was the dissent. Well, guess what? About 24 hours later, we just got this, and it is a legendary dissent. I have never seen anything like this. It is just absolutely brutal. Here is a sneak peek. Just take a look at these one-liners. If this were a law school exam, the opinion would deserve an F. Looks like Judge Brown's so-called direct evidence doesn't amount to a hill of beans. Whether Judge Brown likes it, gravity exists. So does Alexander, referring to the decision in a previous case, precedent. On top of that, Judge Brown embraces a dinosaur-like understanding of equitable remedies. And last but not least, Judge Brown is an unskilled magician. This dissent was penned by Judge Jerry Smith. He's been a federal judge for the last 37 years. He was appointed by President Ronald Reagan, and he's been in the exact same position ever since. He's issued rulings, decisions, stays, injunctions on some of the most notable cases of the last few decades, including the EPA, free speech, constitutional issues. So this is someone who is really well respected, and this dissent is a big deal because this case is going to be fast-tracked to the Supreme Court, and it's going to be up to the court to, decide whether or not Texas can indeed redistrict in the middle of a decade. So the fact that his dissent is this brutal, I think, is giving us sort of a sneak peek of what we can expect at the Supreme Court. Now, at the very top of his dissent, he writes, the main winners from Judge Brown's opinion are George Soros and Gavin Newsom. The obvious losers are the people of Texas and the rule of law. I dissent. He mentions George Soros, by the way, about 17 times in this 104-page dissent. It is just massive. It's long. Now, he does bring up California and Gavin Newsom, and this is really important because obviously there is a redistricting arms race going on. And what is really alarming a lot of people right now is in California, what they're doing is actually race-based. So we now have evidence that they are creating Latino-majority districts. That is the exact wording, the exact phrase that they've used in the state legislature. And so it's very different from what's happening in Texas. On top of all of that, initially, when California voted to allow this redistricting plan to happen, there was a clause in there. Basically, if Texas redistricts, then California will redistrict. So basically, California wasn't going to do anything unless Texas does something. Well, they've actually quietly removed that clause. So now, no matter what happens in Texas, even if, let's just say the Supreme Court makes the wrong decision and they say, hey, these rogue judges were correct and Texas cannot redistrict, well, California, they can choose to redistrict anyways. They can choose to squeeze out as many blue seats as they can. So that's why this is so important. Fortunately, now, before we get into this dissent, one of the attorneys who's on the case suing California believes that, this is eventually going to be struck down. This is what he had to say.
And I'm not sure what the court based that on. Our lawsuit in California says just that. California used race. They wanted to draw Latino districts, and they said that. This isn't a theory or something. The legislators said that when they're passing this map, that they wanted an additional Latino district. So if that is enough to strike down the Texas map, then this one should get stricken down as well. Although the Texas maps, we do believe, are lawful and constitutional, and we do think that's going to make its way quickly up to the Supreme Court.
Well, that would mean that the California redistricting would probably be legal too.
No, because we actually have evidence that the legislators improperly used race to draw the maps. They said it, and they've said it on record. And we're going to have a court hearing on December 3rd, and we'll get an answer very quickly.
Well, it's interesting. The Brennan Center for Justice talks a lot about this, and that there are some 98 cases that are being tracked with legal challenges related to gerrymandering. All told, they report 49 cases raised allegations of race discrimination, often including, referring back to the Voting Rights Act, to various other state constitutions, racial gerrymandering. What do you make of that being used so frequently in these lawsuits?
That's the one thing the Supreme Court's looking at is a provision of the Voting Rights Act that we think sometimes does get abused.
Yeah, and so I mean, obviously, this is going to be a huge case, not just for Texas and California, but the entire country, and quite frankly, the future of the country in Washington, D.C. Well, going back to what happened in Texas, Judge Jerry Smith actually rewrote his dissent at the very last minute. He wrote a new part and inserted it right at the very top. This is what he said. Jerry E. Smith, Circuit Judge dissenting. Fasten your seatbelts. It's going to be a bumpy night. I dissent from the entirety of Judge Brown's opinion, granting a preliminary injunction. Preliminary statement. This is what he added. I append this preliminary statement to dispel any suspicion that I'm responsible for any delay in issuing the preliminary injunction, or that I am or saw slow walking the ruling. I also need to highlight the pernicious judicial misbehavior of U.S. District Judge Jeffrey Vincent Brown. And let me tell you something, the allegations that he's making against Judge Brown, I don't think any judge would make these allegations lightly. And if even a fraction of what he said is true, this is just a judicial malpractice to the highest degree. I am actually, I usually don't read things all the way through on the channel. I try to summarize them, but there is just no way I can summarize what he's about to allege and do it any justice, because this is absolutely crazy. So I'm just going to read the first 3 pages of this pretty much all the way straight through. You can follow along. Of course, we'll talk and analyze and comment on things along the way, but it's just absolutely crazy here. In my 37 years on the federal bench, this is the most outrageous conduct by a judge that I have ever encountered in a case in which I have been involved. In summary, Judge Brown has issued a 160-page opinion without giving me any reasonable opportunity to respond. I will set forth the details. The readers can judge for themselves. This 3-judge district court held a 9-day evidentiary hearing trial on the motion for preliminary injunction, and so he basically gives the details. This concluded on Friday, October 10. The judges immediately retired to confer. Judges Brown and Guadarrama voted to grant the preliminary injunction. I voted to deny. It was understood that the majority judges would begin putting together an opinion. During the next 26 days, there was silence. Nary a word from either judge. On Wednesday, November 5, Judge Brown sent me a 13-page outline of the expected majority opinion so that you and your chambers might be able to begin preparing your dissenting opinion. Nothing else. He received nothing else for a week after that. On Wednesday, November 12, Judge Brown sent me a message stating, we currently anticipate issuing our injunction on Saturday, November 15. We will endeavor to get you a draft before we issue it. Sadly, we do not believe we can wait for a dissenting opinion before we rule. The fuse is simply too short in light of Purcell. We will, however, note on the opinion that you are dissenting. We are not trying to cut you out. We just don't have the time. Ideally, of course, we'd like to have seen your dissent before we issue our opinion, but that will also be impossible. This is just unusual, by the way. Like I said, usually whenever the majority opinion is issued, the dissent is issued in tandem because they get reviewed and the judge, they're supposed to collaborate behind the scenes on all of this, but that did not happen. It actually gets even worse because Judge Jerry Smith actually had to go to a funeral. All of this was well known, and even though he was mourning another judge who died, he was working to get this dissent out, even though the other 2 judges were undermining him. Yes, you heard it right. To summarize, in case the reader doesn't get the point, Judge Brown was announcing that he would issue an opinion 3 days later, an opinion that I had not even seen and might not be furnished before its issuance. That is unthinkable, but it occurred, and not accidentally. A day later, at 10:31 p.m. Thursday night, November 13, Judge Brown sent me a message stating, I've attached a complete draft of our memorandum, yada, yada, yada. It turns out this draft was 168 pages with 655 footnotes. So obviously just an impossible amount for anyone to really dive into, review, and let alone be able to respond thoroughly in a dissent. But that's what the judges did. So Judge Jerry Smith elaborates, I was out of town on Thursday and Friday, November 13 and 14, to attend the funeral of, coincidentally, a district judge of the Western District of Texas, having driven all day Thursday. In my absence, my staff continued working. I drove back home Friday, arriving after midnight, so that my staff and I could spend all day Saturday and Sunday working on the dissent. Early Sunday morning, November 16, Judge Brown sent another message stating, I've attached a newly revised draft of our majority opinion. We're still making revisions, but this is pretty close to the final version. We are now hoping to issue it on Tuesday, November 18. That second draft, by the way, was 161 pages and contained some substantial revisions from the first one. I replied that I'd been out of town, was writing the dissent all weekend, and would be on the road all of the next day, Monday, to attend graveside services for the deceased federal judge. I said Judge Brown had no business issuing an opinion as soon as Tuesday. Yet, despite all of that, at 11:27 a.m. on Tuesday, November 18, Judge Brown wrote the following: I've attached the final version. We still intend to issue it today. I'm sorry that we cannot wait on your dissent. Purcell compels us to get the ruling out as soon as we possibly can. It turns out that's today. That third version, 160 pages, was issued a few minutes later, and it was signed by him and obviously did not include the dissent. This outrage speaks for itself. Any pretense of judicial restraint, good faith, or trust by these two judges is gone. So basically, what the other two judges did was ice Judge Jerry Smith out of this entire thing. They should have been collaborating. They should have been reviewing his dissent and him being allowed to review their majority opinion so that he could properly and fully dissent. But that never happened. I mean, it's hard to see how this is anything but strong-arming and forcing him out of the equation. If they were so confident in their legal wisdom and the decision that they made, why rush this out in the first place? It should be able to stand up to scrutiny. And whenever you have these multi-judge panels, that's the whole point. They're supposed to go back and forth. They're supposed to review each other's writings. And that just wasn't the case here. Judge Smith actually points out that federal judges get paid not only to disagree, but to find common ground. But how can you disagree and how can you find common ground if you're not working together, if you're trying to ice someone out of this and not let their voice be heard in the final opinion? Yes, of course, Judge Smith is dissenting here, but that is the whole picture. It is the overall opinion, the majority opinion, and then the dissent. You can't have one or the other. If you want the full picture, you need both hand in hand. You need both in tandem. But, to put that out there and basically make Judge Smith scramble while he is mourning one of his close friends who coincidentally was another federal judge, I think it's just a low blow, and quite frankly, the actions speak for themselves. Well, Judge Smith really lays into Judge Brown and points out all of his flaws and the errors in his decision-making. But before we get into that, I would like to acknowledge the member of today's Governor's Club. That is Patricia Dixon. These are people who give tips and super thanks to the channel. I'm so glad that you enjoy, and I'm glad that you're here. Well, it is a 104-page opinion, and he goes really deep into the legal theory. I'm not going to get into the weeds there, but I think the best overview is actually this page, where in the interest of time, this dissent is admittedly disjointed. Usually in dissenting from an opinion of this length, I would spend more days refining and reorganizing the dissent for purposes of impact, but of course, he had no time to do that, which is why it's rushed. The resulting dissent is far from a literary masterpiece. If, however, there were a Nobel Prize for fiction, Judge Brown's opinion would be a prime candidate. Judge Brown could have saved himself and the readers a lot of time and effort by merely stating the following: I just don't like what the legislature did here. It was unnecessary and it seemed unfair to disadvantaged voters. I need to step in to make sure wiser heads prevail over the nakedly partisan and racially questionable actions of these zealous lawmakers. Just as I did to the lawmakers in Galveston County and Pedway, I'm using my considerable clout as a federal district judge to put a stop to bad policy judgments. After all, I get paid to do what I think is right. In 37 years, this is, of course, Judge Jerry Smith speaking, in 37 years as a federal judge, I've served on hundreds of three-judge panels. This is the most blatant exercise of judicial activism that I have ever witnessed. And he goes on and basically excoriates them, referring to this joke that apparently is well known in the legal community. So this case already has been appealed. It will be going to the Supreme Court. We don't know when the Supreme Court will hear it, but I imagine it will be sometime soon. But just from the bird's eye view here, the Texas state constitution allows them to redistrict in the middle of a decade. So it's not like what California did, right? In California, they had to vote because they're only allowed to do it at the top of each decade. So we're not even, having the same conversation here. What the judges didn't like was the outcome. It's really clear that they thought that the legislators were making the wrong call. They felt maybe, it was politicized, when in reality, the original map was politicized because it was racially drawn, and what they're trying to do is fix it to make sure that all votes, all voices are equal. So that's why the Supreme Court should overturn this on its face. It is perfectly allowed and perfectly constitutional because the state constitution allows it. Now, as if all of that wasn't a strong enough case, you have this judicial malpractice by the judge here, just this egregious offensive actions, and it's hard. You can't look at that, right, and say, oh, it was just coincidence, oh, unfortunate timing, when there is a clear pattern of trying to exclude someone from this process. It looks blatantly partisan and political, and I just don't see. You take a look at how the Supreme Court has been ruling in all of the cases that involve President Trump that have gone to the Supreme Court in his second term. The court has sided with the Trump administration 92% of the time. So it's hard to see how this will be any different. Take a look.
Bush had 6 injunctions against him. Half of those were issued by Democrat-appointed judges. Obama had 12 nationwide injunctions issued against his administration. 60% of those were issued by Republican-appointed judges. In the first Trump term, he had 64 injunctions. That compares with Biden's 14. And then before the CASA decision, we have a rough count of about 40 issued in the first 6 months of the Trump administration. So over 100 injunctions issued by against the Trump administration. Over 90% of those were issued by Democrat-appointed judges. That means that since 1963, over 3/4 of the nationwide injunctions have been issued against President Trump, with over 90% of those coming from Democrat-appointed judges. Well, some might argue that's just because Trump is more lawless. Well, again, let's look at the facts. 24 emergency petitions were filed at the Supreme Court by the Trump administration this year. They won 22 of them. That's a 92% win rate at the United States Supreme Court. There's not a single other entity, thank you, that...
I have a feeling that when this Texas case gets to the Supreme Court, that 22 is going to change to 23. As always, though, all of this is just my analysis and commentary. That is what's happening in the world of politics from my point of view, and I would love to hear from you. So how confident are you that the Supreme Court will overturn these rogue judges? Pretty confident, or are you just going to believe it when you see it? Let me know your thoughts on this down in the comments below. If you haven't already, please be sure to leave me a thumbs up. I know it's a simple thing to ask for, but it really does help me reach more viewers like you in the algorithm. Be sure to smash that subscribe button and to check out one of these videos.